SJC-12742, Commonwealth v. Sky, A. McGann. Dutch.
Ms. Chayette, good morning. Good afternoon.
May it please the court, Kara Chayette for Sky McGann. Move that. The defendant and the complainant were the only witnesses to the incident at issue in this case. It's undisputed that the complainant, Christopher Roberts, suffered the brunt of the injuries. It's also undisputed that McGann had a viable claim that she acted in self-defense. Because they were the only two witnesses to the incident, Roberts' invocation of his Fifth Amendment privilege on the eve of trial resulted in trial by hearsay. And that's the crux of the case. Before I dive into that, however, there is a clarification, correction, and a little concession on my privilege argument. In the run-up to oral argument, I read Leclerc, and I now understand that I made an error. It's not correct. The DA's representation that he was not going to prosecute Roberts did not vitiate Roberts' privilege. And so I would concede that the Commonwealth is correct, that certainly on the record as a whole, it's clear that the basis of Roberts' privilege was his participation in the assault for which McGann was being prosecuted. But that then dovetails with the crux of the issue. In making his threshold determination about the admissibility of the spontaneous utterances admitted without benefit of confrontation, the judge should have been at least permitted, if not required, to consider Roberts' invocation of his privilege in the context of the defendant's viable claim of self-defense, and the evidence before the judge that the witness through whom those spontaneous utterances were coming was demonstrably interested and demonstrably untrustworthy.
So I'm sorry. So are you saying that the victim did have a Fifth Amendment right not to testify?
Yes.
Okay. So
Yeah.
that's out.
That's out. I mean, I do think what had flagged my concern was the adequacy of the colloquy. I think as I get into the spontaneous utterance issue, I do think that the judge I'm not sure that he fully educated himself about the basis of the privilege and how intimately it was tied to the prosecution of McGann. But yes, that's not an independent argument. And so taking those three things, typically we're really cautious about commenting or drawing any inference from somebody's invocation of a privilege. But in this case, actually, the judge could have. The Guide to Evidence 104A permits a judge in making his gatekeeping admissibility determinations that he's not bound by the rules of evidence, except as to privilege. But the Guide 525B1, the prohibition there is about commenting or drawing an adverse inference against the defendant if a defense witness invokes for the witness's own behalf. Here, the complainant was the Commonwealth's witness, not the defendant's witness. And there wasn't any comment about it, but certainly at that threshold moment, it was something that I maintain the judge should have been able to at least consider, if not obligated to consider, given the self-defense claim.
Well, I think the 104A, as far as the preliminary question of fact upon which admissibility depends relating to an excited utterance, is whether or not it was in response to a exciting event, and also whether the person had time to fabricate it or not. It doesn't go to whether or not somebody asserted a Fifth Amendment privilege. We have no case that says that, and that's not what 104A means about not considering the law of evidence other than privilege when making the determination. You don't consider whether someone asserted a Fifth Amendment privilege in deciding whether or not there was an excited utterance. We don't have any case that suggests that here or
No,
else.
but I'm not arguing either that the presumptive reliability of spontaneous utterances be damaged in any way, But this is the only exception to the hearsay rule where there isn't some consideration of other factors, of the trustworthiness of the speaker, the relationship
Well,
between
it's
the
all
declarant
about
and the
that.
reporter.
It's all about that. The four concerns about hearsay is you can't cross-examine as to memory, ambiguity, perception, and sincerity. So we say that sincerity is mitigated because of the exciting event, and we say that memory is mitigated because there's a certain time frame between the statement in the observation. So just like every other hearsay exception, it has the same indicia of reliability that led to the development of the exception.
Except that it's based on an assumption that people can't lie in that moment, and I think
No, admissibility doesn't mean that the witness is telling the truth. We don't have that what we have is that we're going to accept the hearsay even though it's not as reliable as something else. By definition, it's not as reliable as having the adequate declarant on the witness stand and evaluating what they observed.
Of course not, but all of the hearsay exceptions begin with some presumption that under particular circumstances, like the statement against penal interest, there's something about that that's a little bit more inherently reliable. But even with that, there are corroboration requirements. There's the judge under Galloway and Conway, which I cite in my brief.
There is a corroboration requirement for a statement against penal interest. Of course, the statement against penal interest has less assurances of of truth than does an excited utterance, because the only thing you have with a penal interest is it's against the person's interest. But you do have a corroboration requirement for that. What other hearsay exception has a corroboration requirement?
Well, certainly, I mean, so Zerlong wasn't a pure excited utterance case, that's just hearsay. But there the court said, we don't see any motive to fabricate on the part of the reporters, we don't see any motive to fabricate on the part of the declarant, and there was fresh corroboration.
Wasn't that a forfeiture by wrongdoing case?
It was, but then, so the court said, despite the fact that he forfeited, he had a right, there had to be a high indicia of reliability. This is the filter that we're going to run it through to make sure
That's
it's
because
reliable.
forfeiture by wrongdoing is a hearsay exception that reliability is not mitigated, as opposed to an excited utterance where two of the four frailties of hearsay are mitigated.
So I understand that I haven't persuaded you there, but
I don't understand how you say, I mean, we wouldn't have an excited utterance hearsay exception through all the generations that we've had if there wasn't a view that the infirmities of hearsay have been mitigated as to sincerity and memory.
And it's been so heavily questioned by people about, I mean, it doesn't, I do think it's in most of our common experience that sometimes people come hard, the strongest defense is a strong offense.
You can make an argument that we should eliminate the excited utterance exception. You just can't make an argument that reliability isn't part of the reason for the common law development of it.
So let me try it from this angle. It's one thing to say we're not going to impose any of these requirements, but what about when there's information in front of the judge that screams out, refuting what the spontaneous utterance is and highlighting the unreliability? And let's look at let's actually to the specifics of the 11 o'clock call. So the mother of the complainant, Debbie Roberts, she testifies that at 11 o'clock her son calls her, and what she says, he says, is, "Mom, Sky punched me so hard I can't see, and she stole my car. Call the cops. I will."
Well, that's an argument. Make it even better. That's an argument that it was an abuse of discretion for the judge to decide. It satisfied the excited utterance. Isn't that the analysis you have to engage in?
But, well, if I could, let me then make that second part of that. So she calls him back. Did you call the cops? No, I'm going to bed. She calls the cops 3 times. Does she tell, now she's on a recorded line. Does she say, my son needs medical attention because he's been hit so hard? No. Does she say, my son has a violent girlfriend who's gone, but she's coming back, he needs police protection? No. Does she even say his car was stolen?
Well, those
no.
are great arguments. Those are all great arguments. And I hear you 100%, but isn't that an argument but you have to put into the box, well, it's not an excited utterance. The judge abused his discretion in saying it's an excited utterance.
I think that under King, where it says that the judge has no discretion, King says the judge has no discretion to consider more credible, more reliable evidence in making the determination. And to deny the judge even the discretion to consider these things is to have sort of institutional willful blindness. I mean, how do you defeat that? The confluence of a Fifth Amendment, a legitimate Fifth Amendment privilege for somebody's conduct in the crime for which the defendant is being prosecuted, a viable, undisputed, there was no dispute that she was entitled, after she testified on her own behalf, to an instruction on self-defense, means that the spontaneous utterance without any look at what these circumstances are, it's like some Game of Thrones shield through which just the poison-tipped arrows of hearsay accusations comes through while insulating the declarant. And I think that that can't be right. And as a matter of due process, where I understand that not every hearsay exception is identical, but all of them bear some indicia of reliability. That's why they're hearsay exceptions. And even still, if it's if the defendant is the proponent, we impose some obligation of reliability, even a little bit of trustworthiness. But if the Commonwealth proposes it, then it just, all mom has to do is say he was hysterical, he was crying. Yet here we have an enormously interested witness, and I'm not suggesting per se parents can't be trusted. Blood isn't always thicker than water. But here, what she tells the dispatcher is, I want him to come home from Connecticut. Maybe he was using drugs. He's got a suicide issue. If he's upset, then it doesn't seem like it has anything whatsoever to do with what my client did. It's independent of that. But so then we get to the Graver call at 1:30. And there we've got this black box based on mom's testimony. Christopher calls her sometime between 1:30 and 1:35. A10, I think it is in my appendix, is the log from the police response. They show up at 1:49. We have no idea what is happening in that communication. They may be talking for 15 or 20 minutes. All we know is she says, he says, she tried to kill me, she came at me with a knife. And on this one, I don't want to miss the testimonial piece. Both the Commonwealth and I argued in terms of the knew or reasonably should have known whether the declarant statements were going to be used for purposes of prosecution. About 10 days after I filed my brief, the court issued Wordsworth, in which it clarified, it didn't change any law, but it clarified that the touchstone of the testimonial inquiry is the primary purpose, drawing from Michigan v. Bryant. You look at Michigan v. Bryant, and there the court goes into a very long discussion about the inquiry being not just what the declarant said, but the identity of the questioner, the substance and tenor of those questions. And it gives an extreme example. What if the cop said, who did this to you? We want to go arrest him.
So, isn't it?
I'm
That's
sorry?
that's the point. What if the cop did this?
That's
the
right.
point, because doesn't Ohio versus Clark talk about how unusual and infrequent it is that a statement from one private person to another private person is going to be testimonial?
Yes, but
So you're saying it's the police involved in that changes the equation?
I understand that, but is
that's
it?
your point, isn't it, though, the
Well,
police involvement?
No, my point is it given what we know about what mom tells the dispatcher, for example, and the lack of corroboration and all of that, isn't it just as possible that the mother might have said, Christopher, what did she do to you? We're not going to let her get away with this.
That's a weight issue, isn't it?
I don't think so. I think that goes actually to the testimonial nature of it, even if you don't agree with me that the spontaneous utterance analysis ought to include some consideration of these other factors. I do think that the second call should have been deemed testimonial and excluded on that ground.
Because how is that intended to be a substitute for the prosecution of crime, that statement?
Well, again, I mean, first of all, we know that Christopher, I mean, So he's sitting in the car when he makes this call to his mother. I mean, the facts that we know is that there's some evidence. He's on the phone. He does have an injury to the back of his head. But when he gets out, at least the neighbor looks out and sees that he's got both hands at the back of his head, which suggests that he might have been fearing that he was going to be arrested. There's a relationship between the mother and son here that could he been worried that he's disappointing his mother or afraid of prosecution?
I'm just trying to fit in your argument to how is it that conversation between the mother and the son, right?
Yes.
Would have been objectively meant that the out-of-court declarant would think that it would be for the primary purpose of a substitute for trial testimony.
Come back to the 11 o'clock call the cops. I'm going to call the cops. He doesn't call the cops. Mom calls the cops. When this second call is happening, and there was a police response. So that's where I think the hook is in that regard. I do, if I could make two other little points. One is that there's also the other hearsay from the medical records and from the insinuations and innuendo in the provocative cross-examination of the prosecutor based on his memory of the interview with mom and son. I go into that in my reply brief. I won't repeat that here. The last thing is just because the restitution issue was the other issue raised in the DAR. And two very quick points. McIntyre notes the breadth of a judge's discretion to order restitution, but no criminal defendant can get restitution unless the Commonwealth, as the people's representative, seeks it. The judge's authority to order may not be constrained by 258B, but the Commonwealth's authority to seek it is, and so that's how that builds up. And the other is the court might look at insurers as potential third parties who receive restitution. There's a couple things in my addendum where by plea agreement, certainly an insurer might be able to get restitution, and some of the statutes come yay or nay. All of the ones in my addendum say no. The Arizona statute that I cited says yes, but that's the way a third-party non-victim might get restitution, not how it happened here.
All right, thank you.
Thank you for your time.
Mr. Atala.
Mr. Chief Justice, and may it please the court, Nicholas Atala for the Commonwealth. I was also the trial prosecutor in this matter, and at the voir dire prior to trial, the court did conduct a proper inquiry and into the excited utterances and did follow the structures of King and properly use his discretion to rule those excited utterances admissible. Specifically, referring to the processes of King, although King limits the judge to considering the statements themselves and surrounding circumstances, clearly in any time there's testimony, a trial judge can consider the credibility of the witnesses before them. There's no reason the trial judge could not consider the credibility of Ms. Roberts when she's testifying before the court, and in his finding, I think is an implicit finding that he finds Ms. Roberts' testimony credible as to what her son told her on both of these calls. Turning to the second call, the testimonial.
I'm sorry. Are you saying that he made a finding of credibility?
I don't think he made an explicit finding of credibility, Your Honor, but I think he implicitly, Your Honor, by stating that Mr. Roberts' tone was excited, is crediting Mrs. Roberts' testimony that his tone was excited. For example, if there were an excited utterance hearing where there were two parties to a scene, and one witness says, I heard the witness scream, he's about to kill me, help me, and the other witness says, she said help me, but she definitely didn't say he's about to kill me, and the judge credits the second witness.
You're saying credibility as to the excitability, not necessarily credibility as to the substance of the statement.
Yes, the credibility not of the hearsay declarant, which would be Christopher Roberts, but the credibility of the witness before the court, Deborah Roberts. That is something that the court can consider. With regard to the second excited utterance, the hearsay declarant, Mr. Roberts, was clearly on some sort of notice that perhaps his mother might contact the police when he makes the second call. However, it's important to remember that Christopher Roberts is in the town of Athol, I believe. His mother is in Connecticut. She is nowhere nearby. He is clearly in an excited state. He did not. He said he was going to call the cops the first time. He did not call the cops. I suggest that implies he did not want the cops to be responding to these incidences. And in any event, the cops arrived during his call with his mother in the second event. So the question is whether a reasonable person in the hearsay declarant's position would reasonably think their statements would be used for further prosecution rather than merely assisting in an emergency situation, or perhaps he's just under the influence of a traumatic event and wants to speak to his mother because he's confused about what to do. But ultimately, there's no reason to think that any reasonable person in Christopher Roberts' situation would think that those statements would be testimonial.
But isn't Michigan versus Bryant more helpful here to the defendant? You're citing the Gonzalez doctrine and the dichotomy of testimonial per se and testimonial in fact, where we're looking at would a reasonable person during that conversation think that the primary purpose of the statement, objectively speaking, would be a substitute for trial testimony. And as you just said in your answer, and as the appellants point out, there's sort of a recognition then that might be contact going on with the police about this.
Your Honor,
So why isn't she right about that argument?
Your Honor, I think the important thing to consider is the excitedness of the declarant at the time. So his actual primary purpose, not merely a random person's primary purpose. And I suggest the evidence is clear here that his primary purpose was not to relay information for it to be testimonial. His primary purpose may be hard to ascertain because he may be in an excited state and confused state and just wants to call his mother. And that's the first person
we
he
gotta look
chooses.
at it objectively, with whether the primary purpose that he would understand objectively, reasonably, be a substitute for trial testimony. And the defendant's pointing out, I think, how it's, and you just mentioned it, I might be wrong about this, that there was sort of an understanding that they were in contact with the police.
Your Honor, yes, because the Mr. Roberts had, after the first call, the police had responded at one point and spoken to Mr. Roberts. He knew the police had responded after he called his mother. I don't know if it's clear from the record that he knew his mother had called the police and that's why they responded, but perhaps, let's say that that inference is permissible, that Mr. Roberts, Christopher Roberts, knew that calling his mother in a calm, rational state, he would objectively know that calling his mother would lead to the police coming. He's not in a calm, rational state when he makes this call. And so I think the objective reasonableness has to factor in the excited state of the witness. And that's really the key here, is that if the second call was far more calm and he was saying, Mom, you wouldn't believe it, guess what happened? She did it again in a calm and reasonable voice. Then clearly that's testimonial. I think we're getting closer to testimonial. But here, he's bleeding out of the back of the head. I suggest it's clearly objective that his primary purpose was not to create a record for a further trial.
So let's step back. Let's assume for the moment that all of this is admissible. She is in a different situation in that she only has little sound bites as to what occurred, which are, of course, the most favorable to the alleged victim here because he's speaking to Mom. Is there any unfairness or any concern about the adequacy of the evidence when all we have are we have obviously an encounter of which we know only certain very short sound bites. Did the jury have enough information here to be able to evaluate her self-defense claim?
Yes, Your Honor. I think, first, I don't know if you're really touching on the reliability argument with Sherlong or more of the self-defense claim, but...
No, put aside. Zerlong,
Okay.
I wrote it. It's separate
turning
and
to this-
distinct. But
this-
I'm focusing on the fact that if he had, I mean, the jury didn't know, of course, that the boyfriend is basically saying, I'm not going to testify because of the risk I'm going to be incriminating myself by what I say, which would suggest that he had something incriminating to say. So I understand that the jury doesn't hear that, but is there a concern, that the evidence is not sufficient to prove beyond a reasonable doubt that it was not in self-defense? And here we only have tidbits and we have some observations, but does the jury have enough information to be able to evaluate the self-defense claim?
I think they do, Your Honor. First of all, with regard to the self-defense claim, there is the initial question of whether the jury credits the evidence underlying the self-defense claim. I think here, in this case, importantly, the defendant would not have been entitled to a self-defense instruction at the close of the Commonwealth's case. It's only after the defendant's testimony that she's entitled to that instruction. If the jury discredits her entire testimony, they then don't find any evidence of self-defense. And so therefore, those additional elements of self-defense, Your Honor, I suggest aren't at play, or if they are, that really we're dealing with the first element, whether her force was reasonable. If the jury is finding essentially there's no evidence.
So you're saying then that one need never evaluate the sufficiency of a self-defense claim where it's raised only in the defense because the jury could disregard all of the testimony of the defendant?
I'm saying it's possibly yes, Your Honor, because when you're in Commonwealth v. Haddock, Your Honor, the court clearly says the jury can disbelieve evidence of self-defense, and in that case, they are able to say ultimately that even if there was some force by the victim that justified force in response, or her force was clearly too much. And so they went to one of the additional elements of self-defense. But I would suggest that in this case, if the defendant had never testified, I would suggest, and so never got the instruction, the Commonwealth's evidence would be sufficient to prove the case. And that's how you have to evaluate the evidence, whether ignoring the defendant's testimony, the Commonwealth's evidence was sufficient. After she testifies, but then the jury doesn't believe it, shouldn't really change the analysis. The case law is primarily concerned in self-defense with whether the defendant gets the instruction. The defendant got the instruction here. There's not a lot of case law on whether, on a situation quite like this, Your Honor, but I would suggest that if the evidence prior to the defendant's testimony was sufficient for conviction, then the evidence after the defendant's testimony that is discredited by the jury is sufficient for conviction.
But there's other evidence too here, right? There's the neighbor hears the defendant say, "I'm going to kill you, I want you dead." There's also all the injuries that the victim has that the defendant doesn't have in this. There's clearly a fight, and the defendant's, got all kinds of injuries, bite marks, stab marks, There's a lot of other evidence here.
There's a lot of other evidence there, and also, most importantly, there is the evidence from the police that they saw no marks on Miss McGann when they arrived at the house. So there's no evidence here of a mutual struggle. There's evidence of Mr. Roberts being essentially the victim of an assault, which is what the jury found. And importantly, there are, in the pictures, you can see Mr. Roberts' condition. I believe there's one picture, and I may be mistaken, but I believe there's one picture of some slight scratches on his arm, which would, it's not clear exactly how those were caused from the evidence in the record, but there are a lot of injuries to Mr. Roberts. They're documented in the medical records, which were properly admitted. There are the two neighbors who both heard Ms. McGann say something to the effect of, "I'm going to kill you," screaming it prior to the police arriving. There is Mr. Roberts' appearance and condition when the police arrive, both officers testifying to his appearance and demeanor. So there's a lot of evidence here to support the convictions in this matter on both charges.
But I'm just trying to sort out, so there was certainly an argument, which you just made, to say that, yes, given all the evidence is sufficient for a reasonable jury to have disbelieved Ms. McGann's version and to find beyond a reasonable doubt that she did not act in self-defense. But are you also saying we don't even need to evaluate the other evidence? We can simply say that the jury could have disregarded all of her testimony, not believed it, and therefore we don't even need to evaluate the other evidence to see whether it was sufficient?
Obviously, I think you still need to evaluate the other evidence in this case. I think essentially the jury does that already anyway, because the standard instructions for assault and battery say without justification or without reason. So the jury is already considering that. So I think any standard analysis of the sufficiency of the evidence on an assault and battery charge essentially does that here. And so you do have to look at the evidence. I think there is sufficient evidence here to show that there's not even a mutual struggle of any type, but really that Mr. Roberts is the victim of an assault and battery.
If I can turn you to restitution for a moment.
Yes.
If she had submitted her claim for psychiatric or psychological services to an insurer and Blue Cross Blue Shield paid it, could Blue Cross Blue Shield come and say, "We wish restitution because we paid this amount"?
I believe it would be within the authority of the court to order that restitution. However, I don't think, as a practical matter, courts would be ordering that restitution, because trial courts are considering, when they're ordering probation and not incarceration, the goals of probation, particularly rehabilitation, deterrence, and paying the insurance company. Is that going to also help make the victim whole? Not particularly. Is it going to help make or innocent civilians whole? Not particularly. Is it going to help the defendant understand the impact of her actions? Well, when you're paying a corporation, probably not that much. Are there better ways for the defendant to use her money or use her time on probation than paying off an insurance company. But it would be within the jurisdiction of the court, Your Honor. And I would suggest another example, a larceny where a person steals their grandmother's checks, forges the checks, goes to the bank, and cashes for $500. The bank then reimburses the grandmother's account for $500 should the defendant be ordered to pay the $500 back to the bank. I think if the judge thinks that's appropriate towards the goals of that particular probation, then the judge has authority to order restitution towards the bank, even though the bank is not necessarily the victim of the larceny in this case, or not the intended victim of the larceny.
And as to the issue of the what is the burden in terms of proving that the expenses were causally related to the injuries?
The Commonwealth has to show that the damages were caused, in fact, by the defendant's actions, not just merely the charges, but the specific facts that were proven at trial, and that they were reasonably foreseeable from the defendant's actions. I think that's clearly shown here, that given what the defendant was convicted of, it's reasonably foreseeable that he would need to buy some possible medication for the treatment he received, which is part of the restitution, and then also receive some mental health counseling for the the excited event that he underwent. And so I think it's reasonably foreseeable. If it were reasonably foreseeable that Mr. Roberts would have to make these payments, the fact that Miss Roberts make these payments doesn't change, I suggest, that reasonable foreseeability analysis.
And what if there's evidence that says, well, he was actually seeing a psychiatrist before, and this was simply one additional visit, which happened to be after the event?
That's something definitely a judge can consider, and that would be a factor in the reasonable foreseeability analysis. But there's this is a preponderance of the evidence standard. I don't think the judge abused his discretion in finding by preponderance of the evidence that that burden had been met.
The Commonwealth versus King issue with you can't consider any issues of reliability once the foundation's been met. I have a couple of questions about that. The first one is, in response to the Chief's question, did you say that the judge never made a finding before admitting the spontaneous utterance about exciting event and the lack of reflection?
No, I believe he made some findings. He made some findings of fact regarding the hearsay statements, and I suggested that there was no explicit finding. He did not say, I find Ms. Roberts credible, explicitly on the record, but because he made findings of fact based on Ms. Roberts' testimony, and only Ms. Roberts' testimony, he implicitly found her testimony credible.
But couldn't the judge, if during a voir dire, the information that the defendant says should be considered on credibility, before the judge makes his decision or her decision on credibility, they could consider that evidence, couldn't they?
I think that the court in King was looking to avoid extraneous evidence. I see my time's run out. May I complete my answer?
May finish the answer.
Thank you. The court can
Later recantation.
Later recantation. And so extrinsic evidence to impeach the hearsay declarant, I think, is what the court in King was really going after and not to consider. But there's lots of ways to impeach the hearsay declarant about with the circumstances of the event. Or if there were, well, I think I should say, I'm sorry, you can impeach the witness, Ms. Roberts, but I think impeaching the hearsay declarant, the nature of the excited utterance is what makes it reliable. And as you said earlier, just because it's reliable and admissible doesn't mean it's unimpeachable. And Rule 806 from the Guide to Evidence does say that hearsay declarants can be impeached with any evidence that would be admissible to impeach a live declarant. That was not cited in my brief, Your Honor, but the Guide to Evidence does also mention, and it notes Commonwealth v. Maher, 430 Mass 643, to support that idea. So I don't think the judge needs, during the voir dire, needs to do a credibility analysis of the hearsay declarant, Mr. Christopher Roberts, because that is still available for the jury to do during the trial.
Okay, thank you.